Mr. Gill, welcome back.
Hello again, Your Honors. William Gill again from the Public Defender's Office. In this case, I'm appearing on behalf of the appellant, Chris Green. With the court's permission, I would reserve 5 minutes for rebuttal.
Very good, thank you.
In this case, we've raised 3 sentencing issues. The first 2 sentencing issues pertain to Mr. Green's sentencing range, his range classification. And at least from my perspective, there's an unusual amount of agreement among the parties in this case. We agree, for example, that the trial court committed a constitutional error as to range classification. We also agree that Mr. Green should be resentenced within range 2 instead of range 3. I do perceive a bit of disagreement as to the appropriate rationale that this court should follow to reach that result.
If the state concedes that there's a new sentencing hearing and the new sentencing hearing is governed under range 2, is there anything for us to decide?
Which rationale you should adopt to reach that result is the thing for you to decide.
Can we avoid the constitutional and Erlinger question just by looking at the larceny and saying, all right, this one gets you down to 4, that's range 2, we don't need to address the other?
Judge Swart, I believe that's an appropriate resolution of the case if the court chooses to go that route.
But you'd prefer us to look at the constitutional issue under Erlinger?
No, Your Honor, I express no preference as to that. Of course, I think this Erlinger question is very important. I think it will be litigated.
It's going to be answered sometime,
solved.
right?
So I don't mean to downplay the importance, but from my client's perspective, the relief that my client is entitled to, I believe that issue 2, which is the non-constitutional issue, gets you to the same place as issue 1, which is the constitutional issue.
Help me with this. Does the rationale much matter if we all agree is range 2 and we just remand for a resentencing under range 2?
I suppose it matters to the extent that this court memorializes its rationale in an opinion, and that opinion has an effect on the law. It does not matter to Mr. Green's sentence. So in other words, if this court adopts the rationale advanced by Mr. Green in his principal brief, you would hold that Erlinger prohibits any trial court from making a finding as to the timing of a prior offense at sentencing. And so, for example, an offense like larceny, an offense like the arson prior conviction in this case, those are subject to Tennessee's 24-hour merger rule. And so what this court would hold if it adopts the rationale advanced by Mr. Green is that trial courts are prohibited from relying upon those types of offenses in a sentencing hearing, because to do so requires an unconstitutional factual inquiry.
Under that broad reading of Erlinger, and just for the sake, I think it's a fascinating issue. It's going to have to be resolved at some point. Whether or not it's in Mr. Green's case, it remains to be seen. But if you take that broad reading of Erlinger, doesn't it pretty much completely undercut most of our sentencing structure in Tennessee? Because if you're going to look to determine range beyond the 24-hour rule, which is a different phrasing than the Armed Criminal Career Criminal Act in the feds, the court would have to look at the date of when that offense occurred lots of times, including like foreign judgments. And so if you had to look to see what the date of that foreign judgment, is that going beyond what Apprendi and Erlinger would allow?
Yes, Your Honor.
So we're in big trouble then.
Yes, Your Honor.
Yeah, okay.
Tennessee's
Okay.
range classification, as applied, is unconstitutional under Erlinger. There are a couple of nuanced points. It only applies when the offenses are subject to the 24-hour rule. So the 24-hour merger rule does not apply, for example, to offenses that involve, I believe, actual or threatened bodily injury.
Right.
So, for example, like the robbery prior conviction.
So you just look at the nature of those offenses and say it doesn't matter what the date is. They count, right?
Correct, Your Honor. Even if all those robberies occurred within 5 minutes of each other, Tennessee law would say that they all count separately. For that reason, Mr. Green has conceded that those robberies factor into his range classification, which makes him range 2. But that's kind of an exception. So most other offenses are subject to the 24-hour rule, and they do require the trial court to make a finding as to the timing of those offenses, which is squarely foreclosed by Erlinger. And I do understand that my friend has pointed out I suppose I would call it a possible distinction between the language of the Armed Career Criminal Act under federal law, which was upended in Erlinger in Tennessee's version. We would submit that there is no meaningful difference, that under the federal statute, prior convictions they do not count as separate if they occurred on the same occasion. Whereas
Doesn't that require a little bit more than looking at timing, though? Like, if you look at those federal cases, they dig into more factual implications than we would have to do in Tennessee for the 24-hour rule.
that's correct, Your Honor, but timing is one of the important things that we look
sure.
at, and it tends to be
The one.
decisive. I mean, for example, if you had an Armed Career Criminal Act defendant who had prior convictions in 1960, 1980, and 2000, unquestionably, those could not have occurred on the same occasion, especially, let's just say they were non-continuous offenses. And yet, Erlinger would say the sentencing court cannot make findings as to the timing of those offenses. And so it is a very impactful case. It had a big impact on federal law, and it likely, we would submit, would have the same effect under Tennessee's range enhancement scheme, at least as applied. I think there are other questions lurking about whether this could be submitted to a jury, for example, so that a jury could make the necessary finding and then carry that forward into sentencing. Those are a little bit abstract and not really implicated by what occurred in this case. And again, what I believe Judge Greenholz alluded to and Judge Sword stated, there is a non-constitutional basis for resolving this appeal, which is that the alleged larceny conviction is simply not proved.
Would there be a remedy where you could remand it and require that if there's conviction again on the offenses, a jury make the determination on these prior convictions?
I don't believe that is possible because under Tennessee law, there's a principle that unless there is an agreement to the contrary, the same jury has to decide all these
Yeah.
things. So
That's why I was saying retry the whole thing.
Retry the whole case, correct, right? It would have to be an entirely new trial. I do believe a new trial would be possible, but I don't think you could send it back for a different jury to make the findings that the jury in this case did not make. I will point out that the state has conceded to relief on Mr. Green's first issue, the constitutional issue. I hate to characterize my friend's argument. I'm sure she'll present it to you, but I believe it focuses on the constitutional insufficiency of the documentation of some of these prior convictions, because there were no judgments for most of the convictions and so forth. And frankly, I agree, and I appreciate the state bringing up another constitutional problem with the documentation of the offenses. We, of course, relied upon the more principle holding of Erlinger about the trial court's factual inquiry under these Apprendi principles. The second issue pertaining to the lack of proof of the alleged 1983 larceny conviction is a more straightforward issue of there was no proof. And even if somehow this court were to find that there was proof, there's no proof that it was a felony under North Carolina law, and that would be required for it to count in the...
There was some discrepancy, too, as I recall from the record. It's larceny, and then I think maybe it's the PSR said B&E. I can't remember. So it's not really clear even what that was.
That is correct, Your Honor. In the pre-sentence report, this same case number appears, but the charge and the conviction are listed as breaking and entering. And once again, we would have so that's a different offense altogether, first of all, which is a problem when the state is supposed to prove these things beyond a reasonable doubt. Once again, we would contend, and I believe the state would agree, that a pre-sentence report is not going to be constitutionally sufficient evidence anyway under Erlinger and Shepard and other cases. And in this instance, the pre-sentence report was mixed up on what the crime even was, and if it was breaking and entering, there's no information to suggest that that was a felony or a misdemeanor under North Carolina law. So for more reasons than I can count and what I just routed off, that's not going to count. But the state has not conceded that, so there is kind of a question about whether this court wants to decide this case based upon a conceded constitutional issue or a non-conceded evidentiary issue. Just briefly, I'll mention the third issue pertains to the fines that were imposed by the trial court. The trial court imposed $7,500 in fines, and the state concedes that the trial court made no findings whatsoever in support of those fines. The state encourages the court to conduct a de novo review. I would submit that numerous recent cases from this court indicate that the appropriate course of action in this scenario is to remand for the trial court to make the necessary findings or conduct the necessary factual inquiry before deciding whether to impose those fines.
Particularly since the case would be going back anyway for a new sentencing hearing?
Precisely, Your Honor. So unless the court has further questions, I will leave it there. Again, we ask that this court remand for resentencing as set forth in the briefing. Thank you.
Thank you, Mr. Gill. General Orr, good morning to you.
Good morning, Your Honors. I apologize. I try to avoid drinking water at the podium, but I appear to have a bit of a dry throat this morning. I agree with my friend on the other side, Mr. Gill, that there is an uncommon amount of agreement in this case. We agree on the outcome for the most part, but we just disagree on the avenue to get there. And Judge Sword, as you pointed out, there is no need to address the Erlinger issue in this case because you can reach the same conclusion and remand this case for resentencing as a range 2 offender without addressing the Erlinger issue. As Mr. Gill, I think, accurately characterized arguments in the state's brief that under issue 1, we concede that the proof was insufficient to show that the defendant had additional convictions that would fall outside of the 24-hour period, not because of an Erlinger issue, but simply because the proof lacks, or the record lacks proof as to when these offenses occurred, except for one offense in South Carolina. And without proof of those dates, we cannot show that the 24-hour period would have been satisfied or not within the Erlinger framework or without the Erlinger framework. And without that proof, therefore, we cannot get the defendant to a range 3 sentence. Instead, and as the defendant concedes in his briefing here today, his armed robbery convictions and his common law robbery conviction from North Carolina do properly classify him as a range 2 offender. And this case can be remanded for resentencing as a range 2 offender without addressing the Erlinger question. I agree with the comments made by the court here today and my friend on the other side that eventually this court is going to have to address how Erlinger applies in the state of Tennessee. This is simply not the case to do it. Importantly, we are here under plain error. And Erlinger has not been applied in Tennessee, and as Judge Sword noted in some of his questioning, there is enough difference between the language of the Armed Career Criminal Act and Tennessee's 24-hour merger rule that applying Erlinger under a plain error framework cannot show that there is a clear and unequivocal rule of law about how Erlinger would apply in this situation. And as this court has stated in other
It would be an issue of first impression as well, would it not?
It would be an issue of first impression, Your Honor.
And generally speaking, this court has recognized that issues of first impression, at least in some cases, wouldn't be appropriate for plain error analysis.
Would or would not, I'm sorry.
Would not.
Correct, Your Honor. And you, again, one step ahead of the state, got to where the point I was trying to make. So simply put, this is not the case to address Erlinger's application in Tennessee, and not to speak ex parte, but I do know there are other cases in the pipeline working its way to this court where it is more squarely presented. And there will be a day when this court will apply Erlinger. I just do not believe that this is the case to do so.
Were there any that when I was the trial judge on?
I don't think
I've
so.
got a losing streak going on right now. I'm just praying it's not.
It is from Knox County. I think it was Judge Green. So, because it's me and Jonathan Harwell. That's what I remember. But turning to the second issue, yes, the proof, there's no proof in the record to show this 1983 larceny conviction. I agree with my friend on the other side that the pre-sentence report is muddled and confusing. There are 2 pre-sentence reports in the record because there were corrections made about dates on some of the prior convictions, which gets to our concerns about relying on those as a Shepard document under Erlinger, but again, we don't need to get there. And then additionally, the North Carolina pen packet is equally confusing about this larceny conviction. There's one documentation that lists as a single conviction, I think it's breaking and entering, larceny, and arson with one sentence, and it's not clear at all what that sentence applies to, whether that's a felony conviction. So, but this court need not reach that issue under plain error because per the state's concession regarding this needs to be remanded for a range 2 sentence resentencing anyway, the larceny conviction becomes irrelevant. And then finally, turning to imposition of the fines, I understand that judicial economy makes sense to remand the fine question back to the trial court for the resentencing. And I do not mean to quibble with my friend on the other side's language. I would hesitate to say there was no findings whatsoever on the trial court. The court did make one finding, that the jury for the facilitation of aggravated assault conviction imposed a fine that was less than the maximum. But the state does agree that that is not sufficient findings for the imposition of.
Wouldn't it be sufficient if the opinion of the court identified some of the factors the trial court could consider in whether to assess the jury's fine, and then allow the court to consider those on the record before it?
That would be a valid option, Your Honor. But as the state's advocate, I would just say that the court's failure to make appropriate and robust findings in this case does not necessarily mean automatic reversal. Should this court elect to do so, it can apply de novo review, and we would submit that this record supports the imposition of a $7,500 fine here, simply because Green and his co-defendant deceived and attacked an elderly victim. They lured him outside of his home into a remote area where they violently attacked him, causing him to lose consciousness and have lasting physical damage from the strangulation that they imposed upon him. And then, while he was still unconscious, returned him to his home, and when he started to regain consciousness, the defendant himself threatened him said, if you get out of this car, I will kill you, and made a move as if he was going for a gun on his waist. Again, this was a very, very severe attack, and the court, not within the fine considerations, but when considering enhancement factors, did note that Green had an extensive history of, or extensive criminal history, which we're not worried about the timing just for the fact of his prior convictions. But he has an extensive criminal history and was continuing to pick up charges in South Carolina while this case was pending, which shows that he's not amenable to correction. And finally, I believe that Mr. Green's statements, his own statements in the pre-sentence report, showed that he made several $100s a week and had a financial ability to pay this fine. So we would submit that the record supports the imposition of a $7,500 fine on de novo review, but should this court elect to remand, that's certainly within the court's prerogative. And we ask that you reverse the trial court's imposition of a range 3 sentence and remand with instructions that he be resentenced as a range 2.
General, thank you. Mr. Gill, 5 minutes for rebuttal.
I dare say I will not need that much. We'll see. I just wanted to briefly say on the subject of plain error, in the seemingly unlikely event that this court gets to the question of whether the Erlinger issue is appropriate to address under plain error, I would recommend reliance upon the Tennessee Supreme Court's decision in Gomez, because that case is remarkably similar. It had an Apprendi issue of first impression under Tennessee law. The court said that plain error was appropriate because the Apprendi principles that had been clarified in the subsequent case of Cunningham so clearly applied to Tennessee law. And so while I would agree with Your Honor that it's a little bit unusual, there is precedent for that in the specific context of an Apprendi clarification.
Sure. Gomez was saying, though, that the principles under federal law were clear by that time, and essentially I think that's what you're arguing here as well.
Exactly so, Your Honor. And just very briefly regarding the fines, I don't think the PSR, which we agree is highly unreliable, is quite enough on the question of Mr. Green's ability to pay for this court to conduct the inquiry needed for de novo review. He did say that he had worked, but it's not clear when he worked, how much money he made exactly, when that was. And so while I don't dispute my friend's characterization of certain of the factors, I think especially on the question of ability to pay for someone who is going to be incarcerated for some time, that there's quite enough for the court to conduct a de novo review. With that, unless there are further questions, we ask that the court remand for resentencing. Thank you.
All right. Mr. Gill, thank you. General Orr, thank you very much. We appreciate your arguments today, very well presented. And thank you all for appearing here in December. Thank you. Can we finish now? You good? Call the next case, please.
Yes, Your Honor.